That sounds like 10 o'clock. Let's
go.
call our meeting to order. Welcome everybody and Happy New Year. Let me start with the roll. Commissioner Redcliffe here. Commissioner Parcells
Here.
Commissioner Caruso here. Commissioner McKee-Vasava
Here.
and Commissioner Leipold.
Here.
Terrific. Let me start with pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to the executive session or the next meeting thereafter. An executive session was held on October 22nd, 2024 through Microsoft Teams to review a confidential opinion request and a litigation update. And an executive session will be held today, January 8th, 2025, immediately following this public session to review matters that are by statute confidential, including the review and consideration of applications for 90-day extensions of investigations filed by the Investigative Division and administrative matters. The first item on our agenda is the minutes of the October 11th, 2024 public teleconference meeting minutes. They have been attached for everyone. Has everyone had a chance to review them? May I have a motion to adopt those minutes?
So moved.
And a second?
Second.
Any corrections, comments, anything? Hearing none, all in favor of approving those minutes, say aye.
Aye.
Any opposed? Motion carries. We have a number of civil penalty order defaults, and they have been assigned to Commissioner McKee-Vassallo. Please present.
Thank you, Mr. Chair. So there are 9 civil penalty default cases that are before this commission for decision today. The respondents involved in these cases will be identified individually in the motion I will be making with regard to the cases. These respondents all failed to file statements of financial interest for the calendar years that I will also detail in my motion. The respondents did not take action or otherwise respond to the civil penalty proceedings. Following my review, it is my opinion that as to each respondent, the commission should levy a maximum civil penalty for each delinquent statement of financial interest. It is my opinion that the commission also should order these respondents to file their delinquent SFIs. There is nothing of record that would constitute an offense or excuse for their noncompliance with the requirements of the Ethics Act. So based upon my analysis and my comments, I would like to make the following motion. I move that this commission levy maximum civil penalties against the respondents in the following 9 civil penalty default cases as follows. For the following case, I move that this commission levy a maximum civil penalty in the total amount of $500 against the following respondent for failing to file a statement of financial interest for calendar years 2020 and 2021. And that's with regard to respondent Natalie Rushel. For the remaining 8 cases, I move that this commission levy a maximum civil penalty in the amount of $250 against each of the following respondents for failing to file a statement of financial interest for the calendar year 2022. And those respondents are Lance Wheeler, Carl Ryan, Amanda Stanzione, Byron Williams, Jenny Naugel, Anita Caraway, Sabrina Freeman, and Monet Simpson. Further, these respondents shall be ordered to file complete and accurate statements of financial interest for the year stated within 30 days of the issuance of the commission's order. I so move.
Is there a second?
Second.
Hang on for a second. One comment I'd just like to make, not that there's ever an excuse under our policies for failing to file given all of the remedial steps that the administrative staff takes generally, but looking at Ms. Rushel, a solicitor, presumably an attorney from Green Township, that seems awfully aggravating to have 2 years of failing to file and defaulting on this case. And I just wonder aloud too, I know our orders become public, but whether that should be referred to the disciplinary board of the Pennsylvania Bar, this.
Sure, we can certainly send a copy of the final order over to contacts over there.
Any other questions or comments? All in favor of the motion?
Aye.
Any opposed? Hearing none, the motion carries. Thank you. The next matter is an administrative penalty order under lobbying. I need to recuse. My law firm and myself personally have represented a principal of this company, and given that financial interest and affiliation with the person, it was a representation unrelated to the Ethics Commission matter that I will recuse. Commissioner Reddincliffe, the vice chair, will preside, and I believe this is assigned to Commissioner Caruso. If I can be summoned when you are.
We will do that.
When you are done.
Commissioner Caruso?
Thank you. There is one default administrative penalty case for our consideration. Respondent Catalyst Experiential is a registered principal that failed to timely file either a quarterly expense report or a statement of failure to meet the reporting threshold for the first quarter of 2024. A warning notice was issued to the respondent, but the respondent failed to comply within the 30-day cure period provided. Based upon the record before us, it is my view that the respondent's transgression of the lobbying disclosure law was negligent. In accordance with the Commonwealth Court's decision in Penn Film Group, the record was examined for any mitigating factors, such as those outlined in section 63.6 sub 3 of the Commission's regulations. Other than this apparently being respondent's first delinquent filing, there is no evidence of any other mitigation present in this case. In the absence of any other mitigating factors of record, we are constrained to impose the maximum civil penalty in this case. Before I make my motion, I just have a couple of questions maybe to ask Mary or her designee. Has there anything come up that could be considered mitigating, or have we had any contacts with this group?
Yes, so the investigative division attorney Lehman did reach out to the principal on this matter. He said that he was no longer the principal, but had never done anything officially to make that so, and then had just stopped responding. So there was they didn't provide any excuse, for lack of a better word, for not filing this. So there's no other mitigating factors that we could see.
Okay, so there's other than your contact, no response. I mean, I saw the one individual who was involved as an attorney based out of Southeast PA. Okay, so we've heard nothing.
Yes, he had stopped responding.
Okay, I guess I'm ready to make a motion.
Go ahead.
Based on the totality of the circumstances in this case, including the lack of mitigating factors, I move that this commission levy upon respondent Catalyst Experiential one maximum administrative penalty in the total amount of $48,100 for its failure to timely file with the Pennsylvania Department of State either a quarterly expense report or a statement of failure to meet the reporting threshold for the first quarter of 2024. Finally, I move that the respondent be ordered to pay the aforementioned administrative penalty by no later than the 30th day after the mailing date of the Commission's order.
Thank you. Do we have a second?
Second.
Second. Any comments or thoughts?
How will we collect?
Yeah.
Well, in response to that comment and that question, we have been referring our cases to the Office of Attorney General. We've had limited success in them collecting on some of the cases that we've referred, but we do expect that it will take some time. We have had payments that have been made by respondents on various cases. We continue to hope that we're able to recoup some of these penalties that are issued.
Thank you.
Thanks, Mary.
Mr. Vice Chair, if I may.
Yes.
I will say I was initially concerned that we were going to levy such a heavy penalty without having any response. But it appears to be, to Commissioner Russo's question, an acting entity without, and just not a responding entity. But I do want to commend the investigative division for the work that you did that I do believe is above and beyond what is required to try and get a response, because I think that is a really appropriate step, and it makes this penalty more appropriate feeling, even though I think we are entitled to do it under the law and under our act. But the fact that we went above and beyond, I think, is very important to showing that we are trying to do the right thing. So thank you to the investigative division for doing that.
And I think that's an important point to mention here. I believe that the staff has been doing that on many, in fact, of all the cases. They bend over backwards to try to work these issues out prior to this stage of the process. So, any other comments?
That is the case, and I do want to commend the staff. What we're looking for with regard to the statements of financial interest and even the lobbying disclosure is compliance. I think the process is set up in such a way that that's the first thing. We want people to comply and file the forms they're supposed to file. But they do take extra steps to ensure that there is notice, that we give people the opportunity to make it right. And so they only come to you after all those processes and steps have been taken.
And I believe that's probably one of the reasons that the process takes a little bit longer, is because we try to do that, to reach out to these individuals across the Commonwealth. And subsequently, it just prolongs the process a little bit. But I think it's probably a good thing, because I do want to try to be helpful. With that being said, if we're ready to take a vote, all those in favor of the motion, say aye.
Aye.
Any opposed? It's carries, and we can ask for Chairman Schwartz to come back.
I forgot. Gavel. All right, so we are moving on to administrative matters. And the first item on the agenda is the election of officers. We are back on a regular first meeting in January. I will entertain motions for the positions of chair and vice chair.
Well, I'd be happy to make the motion that we elect our current chair and vice chair to serve this year. You guys have done an outstanding job, and I'm proud to serve with you. And I would move that Chairman Schwartz and Vice Chairman Redcliffe nominated for those positions.
I would second that motion. I agree 100%. It's a great board to serve with. You guys do a great job.
Thank you. Thanks. Let me just open up. Any other nominations for either of those positions?
I move the nominations be closed.
Okay.
Just rolling.
Motion second. Let's take a vote on the motions to re-elect Commissioner Redcliffe as vice chair and myself as chair. All in favor, say aye.
Aye.
Any opposed? Motion carries. Thank you, everybody. Bridget, we have an issue that I don't know that everybody's familiar with. Some of us are, with respect to the requirement to reconsider thresholds for certain financial interest reporting. Can you give us a little background?
Sure. The Ethics Act, Section 1105B, mandates that the commission review the thresholds that are set for such things, the reporting thresholds for gifts, for travel, lodging, and hospitality, et cetera, over the years. And it requires that it be done on a biennial basis. So we last did this in 2023. So this is our biennial review of those adjustments, if there's going to be any. The way that it has been done is we look at the consumer price index to see what the percentage of increase has been since the effective date of the Ethics Act until today. So despite going to law school to avoid math, I actually did some here. So this is the current thresholds for creditors, gifts, sources of income, and transportation, lodging, and hospitality are set forth in the memo for you. And if you look at the consumer price index as to where we are now, it has gone up about 92% and some change since I think it was 1980 when the first one was done. So obviously, if you look at the creditors, for example, which the threshold is $6,500, if you multiply that and to be a 92% increase, it comes out to be roughly $12,480. So, and you can see the other ones that are in here as well. The sources of income is $1,300. The new one would be $2,496. Gifts $250. New threshold would be $480. Transportation, lodging, and hospitality are $650. The new threshold would be $1,248. Since the Ethics Act was codified many, many years ago, these thresholds have never been adjusted or increased. I think obviously the reasons why should be pretty obvious. In a time when we are looking to make public officials and public employees more accountable for things that are done, and of course over the years we've heard different governors impose very strict gift bans on public employees and things like that. The last thing that we would probably want to do would be to make the reporting threshold higher, so that if you received your gift threshold is suddenly instead of $250, you can now receive gifts up to $480 and not have to report it on your statement of financial interest. It's something that you certainly could consider, something in between, any amounts that you would want to consider. My recommendation, I think, would be to stay where we are, as we always have been. I think it would be viewed as, like I said, a weakening or a decrease in accountability for those that we are trying to make, more accountable by virtue of their status as a public official or public employee. Again, I think if you do decide to increase the thresholds, it would require some obvious coordination with the governor's office, the Office of Administration, the Department of State, et cetera, because it would also impact the lobbying disclosure law. So, that would be something to take into consideration. So if you did want to do it, I think we would have to wait at least until the 2026 reporting period for those to go into effect. But again, it's been 26 years, there's been no increase. Given the time that we're currently living in I think the Commission's overall mission to, hold people accountable, I would not recommend that they be increased. But again, I will, defer to whatever the Commission would like to do.
Any questions?
No, it's not math. I did double check math. We would have to do an across the board increase, right? It wouldn't be creditors versus gifts, because I do view them as a little distinct.
I don't think there's anything that would require us to do an across-the-board increase. I think it would look a little bit odd. I probably viewed maybe not as it was intended if we do one and not all. If there's not a very good reason behind why you choose to do one and not all.
I would disagree, and I was thinking similar to you. I mean, the creditors and direct sources of income. I mean, people have gig jobs. You have an eBay business. I mean, this is not just elected officials. This is state employees, and I think we could make a good argument that the creditors and direct sources of income could be increased.
Especially because we include credit card debt
Exactly,
as creditors, and people are struggling.
Right.
And I understand the transparency aspect of it, and I appreciate that, but I also understand the unintended consequences
Right.
is disclosing that you have debt that may not bring the same. I view gifts as very different.
Yeah, you buy a used car, it's ridiculous. These numbers are so low that I think they're unnecessarily low. But gifts, transportation, they need to stay the same.
Wholeheartedly agree.
Now, the opposing viewpoint, just for everybody to think about, just from my personal experience, is we have prosecuted, when I was at the U.S. Attorney's Office, public officials who have had their credit card debt paid by vendors seeking to do business with the city. And I'm thinking specifically Councilman Rick Mariano in Philadelphia. And the amounts were in the neighborhood of $6,500. So the disclosure of having that debt, and many of us, even when you are financially secure, may have credit card balances that are over these thresholds, especially when you put business credit on there. I don't think there's necessarily the stigma of disclosing I have credit card debt. We're not listing the exact amount. We're listing the credit card, the interest rate. I think by now, most public employees and public officials are used to saying I have a city credit card or a Capital One credit card, and it has an interest rate of X%. So from my perspective and experience, I think the disclosure benefits of having public officials and public employees either disclose their sources of debt indebtedness or even gig income that maybe raises a potential conflict, most likely doesn't, is outweighed by limiting those, who may have debt that could be, if we took this percentage, they could have $10,000 of debt, and investigators would not have an easy source of either seeing where that debt is, as in Mariano's case where it was disclosed, but the payment, the illegal payments were not disclosed. So investigators were easily able to say, I'm going to send a subpoena to Capital One because there is credit card debt that was reported on it. So I just offer that, and certainly want to defer to everybody else's view. I think over the years, at least that I've been on the commission, we have said that the burden of the transparency with the lower numbers is not that high and is outweighed by the public transparency of the disclosure.
Amen.
Yes.
I agree 100% with what you said, Mr. Chairman, and I would add that I think the purpose of the Ethics Act and the purpose of this commission is to promote greater transparency in government. And I think by increasing the dollar amounts, that weakens that transparency and that accountability. And for that reason, I would support keeping the limits the same.
Any other thoughts or comments?
My take on this is that I've been retired from the Commonwealth for almost 4 years. I try to stay in tune with what people are talking about. I don't hear anybody clamoring for a higher amount on any of these. And if we were to go that route, I don't know if this is something that we would do normally, but I would think I would want to hold a hearing to hear what other people outside of the commission would, if we had any inclination of going in the direction of increasing it. I personally am not in favor of it, but I'd also be open to hearing what other folks have to say about it if we would move in that direction, or at least think that it's maybe a good idea. But I personally am fine with the current threshold.
I think the public perception of raising the thresholds would be detrimental. So I would be inclined to retain them.
I think all good views, and I think, you know, the points were raised. Does someone have a motion they'd like to make?
I move we retain the existing thresholds.
Is there a second to that motion?
Second.
Any discussion on that particular motion? Okay, let's take a vote on that motion. All in favor of having conducted our required review this year, keeping the levels as they have remained? All in favor, say aye.
Aye.
Aye. Any opposed? Motion carries. Ms. Guilfoy, we have a item about appellate rights and a proposal here that was in our materials to include a disclosure in all of our orders. Do you want to briefly review that with us?
Sure. So this actually came to my attention as a result of a recent case that the commission considered that is currently on appeal, that we did not attach to our final orders the notice of appellate rights for the respondent in those cases. And I went back and I was looking at some orders that I had done at two previous state positions that I held and realized that they did in fact include at the end of any contested case decision a notice of appellate rights for that individual, simply advising them that they do have the right to appeal to Commonwealth Court, directing them to the rule of appellate procedure that indicates what they need to do. And I believe it was at your suggestion, Mr. Chair, that we also included in the notice, because we have the reconsideration regulations that are currently in place that become a little bit confusing in terms of if that individual files a reconsideration request, does that stay the time frame for them filing an appeal? So I also included in the notice that that does not do anything, and that they, if they are going to file an appeal, that they must do so within the 30-day time frame, even if they choose to file a request for reconsideration under the current regulations that we have. And I'm asking that you approve that this document that I've prepared, this notice document, again, I think it's necessary, and I think it may benefit all involved, especially if we get a question on an appeal as to, with the reconsideration in particular being a little bit confusing that we've all talked about. I think this would be very beneficial to not only the commission but to the respondents as well. I think it's a good, fair way to advise them of their appellate rights.
Thank you, and thank you for preparing this. Any questions? Hearing no questions, do we have a motion to adopt this notice of appellate rights?
I'll make that motion.
Motion made.
Second.
Okay. Any discussion on the motion? All in favor, say aye. Aye. Any opposed? No? Motion carries. A more interesting discussion that I think has been supplemented or is about to be supplemented, treble damages, treble penalties. We've discussed this in the context of cases before. Ms. Guilfoy, I understand that you and Mr. Harder have gone back and done a little research on the issue of triple penalties. You've given us a background on that. Can you briefly summarize and make any recommendations that you think the commission should proceed with?
Sure. This is an issue that has come up in prior cases and most recently came up in a case that the commission was considering at its last meeting. And Mr. Chair, you had asked if there was any case law or any prior commission decisions based upon the treble damages provision, which uses the word shall, that the commission shall impose, or that the individual shall pay a sum equal to triple of the financial gain that they acquired through the violation of the Ethics Act. And while it seems rather obvious that the word shall means shall, apparently it doesn't. It doesn't always mean shall, is what I should say. So I went back and I looked through some of the commission's, not some of, I looked at the commission's prior decisions. I discussed it with Deputy Chief Counsel Harder, and the best that we could come up with in terms of a pattern was that it seems that the imposition of travel penalties was slightly more prevalent during the early days of the commission. And again, it wasn't an always situation. It did seem to be based upon the specific facts of certain cases. And the last two cases that I could find that the commission imposed treble damages were both, in some respects, one was an individual who admitted to all of the findings, and the other one was a default adjudication. So one was in 2017 and one was in 2018. So it seems to me that recently it has not been something that the commission has done routinely. The courts themselves have seemed to adopt the commission's ability to impose when it deems, I shouldn't say fit, but when it deems necessary to impose that treble penalty. The court did in one case reverse a decision because the commission did not show that it was an egregious enough or of a case to have imposed the treble damages. So that's why in terms of recommendation, my recommendation would be based upon the commission's history and the case law that we do have, albeit minimal, that the commission should continue on in its current position, which is that the imposition of a treble penalty or damages should be reserved for those cases that are the most egregious or blatant and extraordinary. And earlier this morning, Executive Director Fox provided to me a policy memo from 1990.
I'm sorry, we just located this.
Amelia,
Oh,
did you
sorry.
pass these down? This is from 1990, where the commission adopted a policy that it dubbed criteria for the imposition of treble penalties. And in there, it does seem to support my current recommendation as well as what the commission has been doing in the past, in that it needs to be, or the case that the commission is going to decide to impose any sort of treble damages would be something that they would deem intentional, blatant, or extraordinary conduct and or exceptional circumstances whereby the conduct based upon all of the relevant circumstances warrant such action. And that was a policy that was adopted in 1990, and it does seem to be that that has been followed not only by the commission, but supported by the appellate court as well. So my recommendation would be to continue in that vein. And if you wanted to re-adopt this policy, you could. It's been since 1990. There's nothing saying that it has been, that this policy is no longer in effect. But given the time frame, it's been such a long time. I would encourage you to, if you wanted to re-adopt such a policy, It's my understanding that the executive director, on behalf of the investigative division, has some thoughts on treble damages that she would like to share as well.
Why don't we take that before we have questions or comments
Thank
from the
you.
commissioners? Please go ahead, Ms. Fox.
Thank you. So I had the opportunity to discuss the issue of treble penalties with my legal staff. And we are in agreement that treble penalties are not appropriate in all instances. We see cases that are less egregious, situations where we have public officials who sometimes appear to unknowingly do the wrong thing. Perhaps they don't have good legal advice, or they're in a position where they feel it's an emergency for them to act. And we recognize that. We recognize that not every case is deserving of treble penalties. So we're supportive of this for what it's worth. We're supportive of this particular position. Of course, we'd prefer to see treble penalties be imposed more often by the commission than what they're being imposed. And we'll continue to request that they be imposed in cases that are not consent agreements, certainly. I think one thing, though, that makes it a little bit difficult for us is that we don't have any standards around when treble penalties are imposed. It's just, if it's bad enough, we're going to give treble penalties. I would like to point out that for our lobbying disclosure cases, we have a list of standards that are to be considered when setting what the penalties will be. Also, in the criminal realm, my understanding is that there are sentencing guidelines that allow people to sort of get a sense of where they'll end up. I imagine that's probably pretty helpful in terms of negotiating plea agreements and other settlements. So my something that I think we would ask, or maybe just ask you to consider, would be as part of our regulatory rewrite, perhaps we give some thought to putting in some standards around when treble penalties should be imposed. I think it would help us decide how we're going to handle cases from the investigative division's perspective.
I would just like to respond that the best analogy that I can come up with, unfortunately, is the infamous pornography statement that we know it when we see it. And it's going to be extremely difficult to define what intentional, blatant, extraordinary, or exceptional circumstances are. I think that's one thing that falls within the commission's discretion as to what it is. I think it's in terms of what we do and in evaluating individual cases, I think it would be very, very difficult to come up with if it's this amount of money or if it's those types of things that would be helpful to the ID. I'm not sure that we would be able to insert those or come up with any sort of standard that would be that would fit the policy that has been in place for a while and that has been adopted by all of the commissions, it appears, up until this point. So I think it would be very difficult to identify those types of things in the types of cases that the commission sees.
Valuable comments from both, and certainly we can further consider this as we're actively looking at our regulations and process. I think in part, and thank you, Ms. Fox, for finding, knowing that we had a policy in existence may actually give some standards and allow the investigative division to point to the policy, and if we decide to reaffirm the policy today, that may give us a little bit more in the interim between adopting final regulations. I find it important, and I know we had a case not that long ago where we had essentially, I'll call imperfect or probably wrong legal advice, and we looked at that as a reason not to impose treble penalties, although we did order restitution and found a violation. I think the fact that the Commonwealth Court has reversed in one occasion a treble penalty, saying that there wasn't bad faith established, shows that in this case, shall is not a directive, it is something for us to consider. So I appreciate the research because we should be following the law. it appears that we have been following the law. And I'll open the floor to questions, but in my view, it may make sense to us to reaffirm the now 35-year-old policy, if I have my math correct, and further consider whether changes or additional examples should be made as part of the regulatory process. But comments from anyone else?
I'm sorry.
Go ahead.
Justice Potter Stewart's been ridiculed a lot over the years, but damned if he wasn't right. Sometimes you just know it when you see it.
Yeah.
And so I think the existing policy, old as it is, pretty well covers things, and I would move to reaffirm it.
Did you want to make a comment before we hear whether or not a second to the motion?
I do. First of all, I want to say that I thought this was a very well-done memorandum. For the non-lawyers, it was very clear, very concise, and I appreciated that. I will say, however, after spending almost 4 decades in the legislature, and Paul may feel the same way, I just always thought shall meant
Yeah,
you
right.
have to do it.
I've drafted a lot of laws when I said shall be shall.
And so this really, it just proves that I'm still learning things, even in my old age. And so I appreciated that. But I also think that that while we want to make some changes on the regulatory end of things, it may even be better to make sure that this is a priority in our legislative rewrite that we've talked about, because I always feel better when the statute is perhaps up to treble damages. And then it gives us that discretion from the get-go, and we don't have to worry about whatever it is that we decide, or even what the is this this degree or that degree. I mean, we have the ability to do anything up to whatever it is that we decide to go in that direction. So with that being said, I'm supportive of Tom's motion.
Yes.
So I'm also supportive, but I just want to make sure I do understand the law. We found one decision in which we were reversed on this. Okay, and it was an unpublished decision. Okay, and does that decision reference the policy that was in place?
No.
So I do think we need to be a little bbit careful about how much we're saying the law is very clear here that it's unclear. I don't think the law is that clear, but I do think that we're doing the right thing by making it discretionary. And I think that it does bear noting that it's not like we have a clear mandate from the Supreme Court that we don't have this power. But I support the policy and I support reaffirming it.
No, and that makes a lot of sense, and I think Commissioner Reddycliffe's comment about usually shall mean shall, and administrative agencies like ours should be following the legislative directive. We do have a Commonwealth Court case that says shall doesn't mean shall, it means may. The legislature could either direct us and say shall really mean shall, or that it is up to, and we have the discretionary authority. So I think everybody has made good points there. We do have a motion to reaffirm the policy. Before we get any other comments, and then if no other comments, do we have a second to that motion?
I'll second.
Okay. So we have a motion to reaffirm the policy for treble penalties dated August 16th, 1990. Any comments? Hearing none, all in favor say aye. Aye. Any opposed? No? Was there, I'm sorry, before I finish the vote, was there a question?
Can we just have one moment, please?
Yes.
No comments.
Okay.
Thank you.
Thank you.
Oh, absolutely. I believe we had a motion that was voted upon. Was there any negative votes? I don't think think I got to that. Hearing none, that motion carries. Thank you all. And again, thank you, Ms. Guilfoyle, I did think for both lawyers and non-lawyers, the memorandum was very helpful and well done. Great transition to Ethic Act revisions. I know there's no action item here. Can you give us a brief update? I know we have materials and it may be somewhat premature given the new legislative session that's upon us, but can you give a little bit of background as to what's going on?
Sure. In the fall of last year, the Chief of Staff to Senate Minority Leader Jay Costa, a gentleman by the name of Luke, I think it's Miron, approached Executive Director Fox about the possibility of doing some revisions to the Ethics Act. And interestingly, he still had in his possession a memo that had been drafted by former Executive Director and current Commissioner, Robert Caruso. And in that memo, I believe it was from 2013, I believe, Commissioner Caruso had outlined a number of proposed revisions to the Ethics Act that would be helpful to the Commission if they had been considered. Obviously, that did not go anywhere from that point. However, Mr. Miron advised that he wanted to get, at that time, Senator Costa to take up the cause. And in doing so, there was a very bright legal intern in the office of the Democratic Caucus. Her name was Camille Penman, and that she would be helping Mr. Miron to draft any changes that they would like seen or that we would like seen. We met with them, we meaning Executive Director Fox, Deputy Chief Counsel Harder, and myself. We met with Mr. Miron and Ms. Penman to discuss it. We indicated to them that while we as staff were in favor of amending the Ethics Act and certain provisions, that we could not make any affirmations on behalf of the commission itself, that was something that would have to come from you. We did indicate some of the revisions that we thought would be helpful, including I think most, if not all, of the recommendations that Commissioner Caruso had made back in 2013. And based upon that memo, as well as the discussions that we had with Ms. Penman and Mr. Miron, Ms. Penman drafted some suggested revisions to the Ethics Act and provided those to us. And I have provided the proposed revisions that she had sent over to you guys. And we recently learned that Mr. Miron was no longer going to be with Senator Costa, that he was now going to be the Chief of Staff to Senator-elect Patty Kim. However, he did indicate that he intends and would like Senator-elect Kim to take up this issue as part of her legislative agenda for this coming session. So based upon that information, the staff here took a look at the proposed revisions that had been drafted. We met several times to discuss those revisions, and we actually did some revising to the proposed revisions as to things that we thought were more along the line of what we would like to see as staff to the commission for those changes. Again, I provided those changes to you as well that we have proposed. And again, there's a lot of uncertainty right now as to whether Senator-elect Kim is even going to take up this issue. Obviously, I think we're all hopeful that she will. And that there will be some sort of co-sponsorship memo circulated. I have been not so subtly advised that it would be good if the commission would indicate its general support, I guess is the way to put it, for revisions to the Ethics Act moving forward. in terms of whether they were going to get Senator-elect Kim on board or not. So we provided to you, again, it's more for your information than for anything else, the changes that were proposed and then our proposed revisions to those changes. There are some that we think are pretty important, and especially we have asked for the trouble penalty section to be changed a little bit, and we've also asked that an additional ability to impose a separate fine or a civil penalty be given to the commission. I'm sure Mary can speak to some of the other recommendations that were made, to Ms. Penman and Mr. Maron as part of this process.
But
Sorry.
I'm certainly happy to do that. Yeah, they're all out, all of these changes are outlined. I think we have consistency among staff about things we'd like to see happen. Some of the things that I think might be useful would be to change the SFI filing location from locally to centrally here. I think when the Ethics Act was originally drafted for people to file locally, it made sense because they live down the street maybe from their township office. Now with the internet, everything can be here. It would be much simpler, it would be much easier for our investigative staff and our administrative staff to keep tabs on the statements of financial interest filing. One other topic I'd love to see, and I think in batting it around, I think we have the capability to do it, would be a mandatory ethics training for all public officials. With the internet and with the ability to go online on your phone and take a training, I think it'd be extremely helpful for everybody that's serving to take a yearly training, and it can be something simple that aligns with the SFI filing requirements. Let's see, other issues. I'd like to clean up some of the language involving subpoenas. I think that's very important to make it very clear that the investigative division can issue subpoenas as part of its investigations. I think our regulations make it clear, but it would be nice to delineate that a little clearer in the statutory language. I
think one of the things that I would add from a council standpoint is we wanted to, as you're aware, when someone files an answer to the findings report, that a hearing has to be scheduled immediately and held immediately, and most of the time they will agree to a waiver of those timeframes, but there has been at least one occasion that has not been the case. So one of the proposals that I made was that those timeframes be moved out a little bit. It's simply not realistic in today's age to get a hearing done in that timeframe and a decision done, especially in terms of the commission's meeting schedule, et cetera. We would be scheduling special meetings a lot. So we did ask that those timeframes be moved out and expanded a little bit.
The other big one from the investigative division standpoint is adjusting the language of the statute so that we could recoup restitution in the instance where the financial gain is not going to the public official, public employee directly, in order to sort of address the issues that were raised in the civic line of cases.
Any questions or comments from the commission?
One comment I make as a former solicitor to some number of municipalities, I think mandatory ethics training for public officials would be wonderful.
Yeah.
Because I used to do a session every year and it was sparsely attended. And I did it as a freebie. So that would be a very, very beneficial thing.
Yeah, agreed.
I have a logistical question. How does this interplay with the reg work that you're undertaking, and does that change our timelines at all?
It may. Again, until I see that this gets any sort of actual traction, they can, again, it may be Mr. Miron's idea, but until we get a senator on board.
It's a freshman senator in her first term, right?
I think we probably stood a much
minority
better
party.
chance
Exactly.
with Senator Costa than who's a longtime person rather than Senator Kim. But in terms, I would like to keep moving forward. the reg process is so long that we would have more than, an opportunity to revise if we ever get some notification or some hint that this could possibly move forward with revisions to the statute.
So are you looking for an expression of support from the commission to the staff's proposals at this point?
Yes, I am actually. Mr. Moran would like to see that, I think, before he's going to go to Senator Letcam.
How do people feel about a motion offering support for the staff's recommendations should there be legislative proposals, and obviously subject to a review of the precise proposals that end up in the legislation, if it happens?
I mean, I also think that you could do a general support of revisions to the Ethics Act, not necessarily these specific ones, but.
I'm more comfortable with
Yes,
that.
okay.
Yes.
Because those recommendations were 2013, and I thought there were revisions made by the commission later on during my time as executive director, maybe 18 or 19, where the entire commission had input. So I don't know if they're in the old records, you may want to find something else, but I agree with Paul about the general recommendation.
Okay.
And do we have a consensus? I don't see this necessarily as a particular motion, but are we all in agreement and certainly delegate the authority to the staff to discuss these issues without committing on the commission's final position? Hearing that, I think you have that statement of support.
Thank you.
Let's turn, Ms. Fox, to an operational report.
Yes, thank you. So I've outlined some items in the materials that we've submitted to the commission, but I'll hit on some of the high points. From a budgetary perspective, we are, as of at least December 2nd, 2024, these numbers are always changing, of course, but we are looking at an available balance from our 2024-2025 budgetary appropriation of $494,000. The reason that that's so high is because we have open positions. And so we have a lot of additional personnel money until the vacant positions are filled. We expect that to remain pretty high. I'm hoping that that'll drop, which would be a good thing because that means that we have money we're being spent on personnel. Last year, for the 2023-24 year, we still have money that was waived over in the amount of $61,631. So we also have additional funds there. As of December 2nd, 2024, we have a continuing appropriation fund balance of $176,000. That was here when I started almost 3 years ago. We have not touched that, and we plan not to. We're going to keep that for an emergency. Moving on to external training, we've continued to engage in training upon request. In 2024, I'm actually really proud of this. We performed more live, virtual, and in-person trainings in 2024 than we have ever done in the records that we have. We conducted 39 of those trainings. Currently, we have 15 scheduled for 2025, but they can't come in all the time, so I expect that number to go way up. I really want to commend our Director for Enforcement, Litigation, and Education, Jen Lehman. She's begun doing trainings as well. She has gotten wonderful reviews, and hoping that in 2025 she'll be doing more of the trainings. Chief Counsel Guilfoyle's done some in 2024 as well. Again, just wonderful feedback, and really looking forward to assisting Counsel Carabin starting to pick up some of our trainings. Two things I'd like to note that I'm also very excited about. On January 30th, we are offering the first ever virtual Statement of Financial Interest, get it done right, get it done on time session, where anybody can just get the Teams link. It's open to anyone that would like to attend. They can get in to the training. We're going to have everyone get their SFI form out, whether that be the web form or the paper form, and fill it out as we go through it. We're going to help people get it done right, get it done on time. Last I checked yesterday, we had just about 40 people registered. We've reached out to our contacts at the township supervisors, Pennsylvania Municipal Authorities Association, and other similar organizations to blast it out to their members. Hopefully we have a good response. Maybe we'll be doing another one this spring, but really we want to be a resource for people to feel confident that they're getting these obligations done correctly. And I also noticed that the chair is attending, so happy to have you there. If anyone else would like to attend, you're certainly welcome, and we'll be sure that you have the link. And then another initiative that I'm also looking forward to is we are partnering with the Pennsylvania Office of Open Records to do a Good Government Symposium. That's scheduled for March 19th. We're still kind of pulling it together, but our plan is to cover sort of the big three good government laws, the Sunshine Act, the Right to Know Law, and the Ethics Act. We may also touch on Act 22, which is seeking the video records for police, because they're sort of one that's looped in with the Office of Open Records. But I'm happy to be collaborating with a sister agency on this, and we're going to work through all of our channels to get this advertised. It'll be a 2-hour virtual session, so stay tuned, and you'll all get the advertisement and the link for that. We're also doing, and I didn't put it in here, but we're also next week, the week after, in fact, we're doing, Bridget Guilfoyle and I are doing a training similar to the Statements of Financial Interest, Get It Done Right, Get It Done on Time. We're doing a similar training for the Senate. We are videotaping that, and as I understand it, that will be shown to all the senators and staff. So we did this 2 years ago, a more general ethics training, but certainly looking forward to doing this with our friends over at the Senate.
Did they come to us, or did we approach them?
So they came to us and asked us. They've done that every other year. And we go over to the North Office building in one of the, I believe it's a committee room, and we're videotaped there.
And the House never approached?
We've had discussions with the House. We've offered training. I think that they have staff, their own staff that does the ethics training.
Used to,
yeah.
when I was there.
So they do. They have ethics attorneys on staff that they specialize in ethics. And we talk to them from time to time. And we've offered our support. So we'll continue to get the word out about the Ethics Act. I say I'll train anyone and everyone that will listen to us. So we'll keep that up. In terms of advisory opinions, we've issued 80 this past calendar year. In 2024, the investigative division has opened 38 cases. 11 of them were opened into full investigations. From a staffing perspective, we now have Assistant Counsel Julie Carabin. She joined us just recently. I'm thrilled to have her on board. She's doing a wonderful job, and I look forward to the work she's going to do for the commission. Also from a staffing perspective, we've unfortunately lost 3 special investigators, 2 from the Harrisburg office and 1 from the Pittsburgh office. We are posting for those open positions. They should be posted either tomorrow or right before this meeting started. I got notice it might be the 13th. But we've been working to get those posted since December. I'm hoping that we have some good candidates. We've also had some discussions with potential candidates from a sister agency. So hopefully we'll have some promising candidates through all of these processes where we've put out feelers and requests. I've let you know previously that we were moving from regular calling to teams. That has been fully accomplished. We had a couple of bumps at the beginning, but we've really worked it out. Staff likes it. That's what they've expressed to me. What happens is this allows our staff to work fully remotely as if they were here in the office. So if you were to call our main line and I was working at home and I was in the call recipient list, it would ring in my home on my laptop as if I were at the front desk. Now, I will say we always have staff here in the office. We will always have a live person available to answer the phone no matter where they are. We will always have someone here in the office, but this just really allows for redundancies and it makes it easier on people. So it's been well received. We've completed our website redesign. We're still working out some tweaks as we find them through the website. But it does have a different look and feel. Many thanks to our IT administrator, Sean Firestein, for his work on that. And then the last thing that we've begun, really at the very beginning steps of it, is since we are hearing that we may have some additional waiver money again, we had some discussions about how we could best use it. And one thing that we identified was the potential of redesigning our statement of financial interest filing system. Currently, it's available to anybody that files their SFIs. You go in, you fill out the form, you do like an electronic signature where you enter a few digits of your social security number, and then it gets filed with the commission. But in order for you to meet your filing requirements, especially at the local level, you need to print it out and you need to file it at the local filing location. What we've talked about, what we think would be wonderful, would be that we would have a system where people could file with the State Ethics Commission. They could create an account, and through some of the tools that are contained within the web design, it would actually send the statement of financial interest to your local government filing location and complete that loop. We do have the technology to do it. We've been in conversations with the same company that performed the web redesign for the entire Commonwealth. We've had discussions with them. They've given us a very large range of cost, just so we can get a sense of what it'll cost for budgeting purposes. It's something that I'd like to continue to explore, because I think it would be a really wonderful tool to offer to our public officials, public employees, make things a lot easier for people. So we'll continue to work through that and provide you updates as we go. We would need to work through the formal Commonwealth's procurement process, so we're really at the very, very beginning stages.
Mary, what's the high end?
$450,000, and that's for, the way I envision it is I wouldn't want to just roll this out. I would want to do a pilot, work out the bugs, and then roll it out a subsequent filing year. So they had estimated about $350,000 to $450,000 to get to the pilot stage, and then another $50,000 to roll it out for the world to use.
Something that large, we might think about asking for one-time supplemental appropriation.
Sure.
Since it would apply for the entire Commonwealth, so.
Absolutely, and I think, if we got to the point where some of these legislative changes occurred, where we would have the Ethics Commission as the central filing location, this system would work. It would be really kind of seamless. People would just file here instead of us routing it out. Sure.
We next have, and I think we started this, but we had an incomplete version. You put together, Ms. Fox, a policy on succession. If there were instances where you or others were conflicted out or unable to act as the executive director, a formal policy delegating the authority.
I did, yes.
Is there any questions that anyone has about that draft policy? I know we saw most of it. I'll just point out that, we retain as the commission the right, and this was on the last page that I think was missing, that if there, was an executive director that had a series of conflicts that made the performance of the position difficult, we would have certainly the right to appoint a new executive director as we retain any time. Not that we have any concerns about that today. But is there anything you want to say before we take the matter?
No, I just wanted to ensure that you had seen the entire full
Yes.
policy. We discovered after the meeting that we had missed a page, so I wanted to bring it back to you to ensure you had a full understanding of what we were looking to accomplish and we're voting on a full policy.
Absolutely, I appreciate that. Do we have a motion to approve this succession policy? A second? Second. Any questions, comments about that? Hearing none, all in favor, please say aye. Aye. Any opposed? Hearing none, motion carries. So before we get to public comment here, I want to take the chair's prerogative and recognize and say goodbye to one of our own. Unfortunately, this is the last commission meeting for Commissioner Leipold. We were very fortunate to have Commissioner Leipold, especially with his background as a former district attorney. I want to talk a little bit more about his varied background. He mentioned being a solicitor today. I think up until today, you have provided, including today, have provided tremendous and valuable insights to the commission. We certainly will ask Senator Ward, who was the appointing authority for you, to try to find someone with your background and talents, because you've made an incredible addition to the commission. Commissioner Leipold's not leaving because he no longer likes the work of the commission. I think he has had a wonderful opportunity to move and ultimately is not going to be a citizen of the Commonwealth of Pennsylvania and therefore ineligible to serve on the commission.
Yes.
The Commonwealth's loss will be South Carolina's gain here. And maybe there's a role for our colleagues in South Carolina to tap Commissioner Leipold's expertise. You did make it a full year. Commissioner Leipold was appointed to commission on January 2nd, 2024 by, as I mentioned, Senator Kim Ward, the President Pro Tem of the Senate. For those who don't know or don't remember, prior to your appointment, Commissioner Leipold served as the elected district attorney of Columbia County, Pennsylvania for 12 years. Previously served 8 years as the first assistant district attorney of Columbia County. And in addition to his numerous trial cases ranging from homicide, they included other felonies and drunk driving, but he also implemented and participated in several diversionary programs for non-violent offenders, including the Columbia Montour Treatment Court program, one of many in the Commonwealth that I think have saved numerous citizens from having permanent records and gotten them the treatment that they needed.
Some of my most rewarding work was there.
Yes. Prior to all of this public service, Commissioner Leipold had a private practice in Bloomsburg from 1985, where he focused on civil litigation, commercial and real estate, but also had an extensive, and this was incredibly helpful, background in municipal and local agency law, representing multiple county and municipal governments in Columbia and Montour counties. We learned today that they receive free services on ethics. We wish in some of our past cases that the solicitors had done as much education as Commissioner Leipold provided to his clients. Commissioner Leipold has had cases throughout the Commonwealth, argued in the Pennsylvania Supreme Court, Superior Court, Commonwealth Court, United States Court of Appeals, and has had the privilege of hearing arguments of issues before our administrative commission. So, with all that said, the insights, as I mentioned before, have been invaluable. The staff have appreciated your input, and what came to me, and I think came to the others from your year of service, is that you truly believe that people should be treated fairly, and you also truly believe that people should be held responsible for their actions. And we are grateful to your service, your commitment to public service, your commitment to the Commission and the Commonwealth. We have established a practice. It wasn't ready yet, given the quick nature of the decision to forego your citizenship of the Commonwealth, not of the country. But we will be presenting with you with a flag of the Commonwealth that has been flown over the Capitol. We don't have it here today, but we will make sure we have forwarding addresses and get it to you. But on behalf of the Commission and all of the staff, we wish Commissioner Leipold the best with all his future endeavors. So thank you.
Thank you, Mr. Chairman. You're very, very kind, very generous in your comments. And I've greatly enjoyed my service here. It's been a real honor and a pleasure to meet all you folks. The staff is wonderful. You've all been very accommodating and welcoming to me with your greater experience at this than I have. But I really enjoyed my time here. And were it not for the very unique and limiting opportunity for relocation that we have, I would very much have enjoyed serving the balance of my term. But sometimes shit happens.
We understand, but we're not going to let you go yet because we do have the final parts of this public meeting and an executive meeting that we're going to hold you to. So your service has not yet ended. Your resignation has not yet been accepted. With that, we will open the meeting to public comments. I know that there's at least one member of the public that would like to participate. Sir, I can ask you to come up and if you can identify yourself.
Yes, I'm Mark Stuckey, and I appreciate the opportunity to speak with you about my experience as a complainant and the delays that I've experienced in seeing my complaint acted on and a preliminary investigation opened. And I would hope and I plea for you and the staff to make shortening these delays a priority in the coming year. So I have some prepared remarks. If you don't mind, I'm going to go ahead.
And Mr. Stuckey, certainly, we want you to say whatever's on your mind. We certainly appreciate you coming, sitting through the meeting and providing. I want to ask you, we, as you know, under our statute, do not identify complainants. Complainants are allowed to identify themselves. And because of the matter that you're talking about, we serve the commission as both the administrative authority over the commission, but we also are ultimately fact finders. So I'd ask you, to the extent possible, not to talk about any of the details. We'd ask you, and I know you do have some comments about process,
Right.
and we would love to hear your comments about process. We're not going to limit you, but
No, I
we'd
understand.
rather not be in a position where if ultimately we're asked to adjudicate anything, this is not testimony of a particular hearing.
It would be highly counterproductive of me to say
Understood.
something that's going to make it impossible for you to process my complaint. I talked to Mary about that, and I think my remarks are very much process-oriented, so. But
I didn't mean to interrupt you. Please go
I
ahead.
totally understand that, so and I also recognize there are rules about talking, there's a law about what you talk about in terms of submitted complaint, and I've tried hard to avoid that in my activities in general, so.
Understand, and thank you very much. I didn't mean to interrupt you. I just wanted to lay that out.
Okay, so justice delayed is justice denied. This foundational legal maxim is often attributed to William Gladstone, but mentions of the concept can be found in the Bible, the Magna Carta, and the writings of William Penn. Martin Luther King Jr. wrote that justice too long delayed is justice denied in his letter from Birmingham jail. Unfortunately, the Pennsylvania State Ethics Commission violates this important fairness precept in its handling of complaints apparently routinely. More than 1 year ago, on January 3rd, 2024, I filed the required affidavit outlining what I believe are numerous and egregious violations of the Ethics Act by a local official. On January 12th, I received a letter from the commission notifying me that my complaint was, quote, being reviewed, and that I would be notified of further action on this matter. A year has now passed and nothing has happened. No investigation has been initiated. I received no further official communication from the commission. I've inquired about the status of my complaint on several occasions. Just before Christmas, I had a good discussion about the status of the complaint with Executive Director Fox. She assured me that the complaint meets all the requirements for a preliminary investigation and that one would ultimately be opened, but was unable to give me an estimate of when this might happen. With delays like this, the Ethics Commission cannot be fulfilling its purpose of, quote, strengthening the faith and confidence of the people of the Commonwealth in their government, which is what the Ethics Act provides. In fact, one can argue that by failing to respond to complaints in a timely fashion, the Commission contributes to cynicism about how and whether the government addresses corruption. Let me provide some more specifics about a few of the many deleterious effects of this pattern of delay. First, the delay allows questionable behavior to continue. In my situation, I made the issues public, and I believe the bad actions have stopped. But in many other instances, I'm sure the bad behavior continues. This is obviously very undesirable. Second, as I suggested, if the behavior has been made public, members of the community will wonder why nothing is being done about it and may ultimately question whether the allegations have any validity. I know investigations are confidential, but in a small community, word gets around. Moreover, the sooner an investigation starts, the sooner it can be concluded and the results made public. Thirdly, the passage of time makes investigations more difficult and makes it less likely the evidence required to make a case against a perpetrator will be found. Memories fade. Documents are destroyed, either in the ordinary course or as a cover-up. People move on and even die. In fact, in my case, a person who would have been a very important witness has passed away subsequent to my filing of the complaint. By being required to pursue these stale cases, your investigators' jobs are being made infinitely harder. Fourthly, statutes of limitations may expire, either under the Ethics Act, which I know you try to monitor, or other laws for which the Ethics Commission may make referrals to law enforcement. In my particular case, I believe there were violations of the second-class township code for which the statute of limitations has already run. The district attorney in my county has refused to pursue these violations until the Ethics Commission completes its investigation, so these offenses will never be prosecuted. Finally, and importantly, the accused is denied an expeditious resolution to his or her case. The U.S. Constitution provides a right to a speedy trial. If the alleged perpetrator knows a complaint has been filed and it hangs over him or her until the investigation is done, both the community and the accused have a strong interest in having charges addressed promptly. The injustice of delay inures to both sides. It should be clear that the current slow timeline for addressing complaints is harmful to the public. It undermines confidence in government and thereby subverts the main purpose of the Ethics Act. I hope that the Commission sees that this situation is not acceptable. Why should it take, say, more than a month to determine whether a complaint merits a preliminary investigation? Based on my conversation with Ms. Fox, these delays are mainly due to a lack of investigative resources, and we just heard about 3 investigators leaving. Investigator positions are vacant for long periods of time. They're difficult to fill, and once filled, the Commission finds it difficult to retain these employees. And even if all the positions are filled, that may still be insufficient. What would it take to eliminate the backlog? Maybe spend some of that extra money. I urge the Commission to address this problem as a top priority for 2025. It's not for me to tell you how to manage this situation, but based on my business experience, I think it's clear you need to analyze historical performance, intake, and backlogs to determine what staff levels are required for acceptable performance, and then address whatever barriers exist to reach those staffing levels and to maintain them. In the State Ethics Act, the Commission has an excellent tool to address conflicts of interest of government officials across the Commonwealth. Considering all the time limits included in the Act, for example, the 180 days to conclude an investigation, I think it's clear that the legislature intended for justice to be administered swiftly. Surely it did not contemplate that it would take more than a year to open an investigation and start the clock, and I doubt that many legislators are aware of these delays. As I stated at the outset, these delays in administering justice are in effect denying it. An act that could be such a positive influence on public confidence in their government risks being another contributor to the public's cynicism about the lack of consequences of bad behavior by government officials. The good news is I think you have the power to fix this. I hope that you will take the actions necessary to put ethics enforcement in Pennsylvania back on track. Thanks.
Thank you, Mr. Stokey. Any comments before I make a comment or two in response?
If you don't mind, Mr. Chairman.
Please.
I'm in a little bit of a either unique or unusual situation, having been in Mary Fox's position, and I've held investigative positions with the commission in addition to being the executive director. And I certainly appreciate your comments, and I think you make some excellent points about the delays. But coming from someone who has gone through this over the years, the staffing issues and resource issues have been ongoing for the commission since 1979 when the commission was created. And I think it only has been more recently, maybe the last several years of my tenure as ED, and Mary Fox has done an excellent job with budgets in the last 2 or 3 years, that they're just finally starting to get maybe some more resources where the commission can bring on staff. But hiring staff and retaining staff has always been a problem, whether it's with the Ethics Commission or with other investigative agencies. And dealing with the Ethics Act, it's a unique law. It's not a law that's, we can hire an investigator who deals with the Crimes Code. The Ethics Act is completely different, and it takes time to get someone up to speed. And when you run into these situations where you bring on some people, they realize this may not be their career, and they leave, and you've spent 6 months to a year training someone, and you don't have the problem. And I would just end with, I certainly appreciate where you're coming from. I think the staff is very conscientious. I think they're dedicated toward working toward the resolutions that people are seeking, but it's just, we're in a bad situation right now, and I've just asked for your continued indulgence until we can get the matter resolved.
The only thing I'll add, I think I speak for everyone in saying we agree with you. Justice delayed is justice denied. That being said, and the way we're set up, we don't know about this particular matter. We don't find out about matters until either there's a resolution, there is a charge and a need for a hearing where one of us or more will sit as hearing officers, or that there is a dismissal. And we rely, and I think we have had good reason to rely on our staff to triage the cases. I'll comment from my personal experience. I spent 15 years as a federal prosecutor, including doing public corruption work. District attorneys' offices and federal prosecutors don't wait on us if the facts show probable cause that a crime has been committed and that there's sufficient evidence to prove beyond a reasonable doubt. Commissioner Leipold had these cases as the district attorney. I don't comment on your circumstance because I don't know.
Wasn't my experience, I will tell you.
No, but I can tell you there is no legal requirement for a prosecutor to wait. And in our experience as a commission, in egregious circumstances where there is both Ethics Act violations civilly and criminal violations, the criminal case generally takes precedent. That's just been my experience. I also want to comment on your point about complainants and people knowing. We have a secrecy requirement. No one who is of our staff is telling anyone about a investigation other than when they're meeting with witnesses and what's required for their job. There is also enshrined in our Pennsylvania Constitution a right to reputation. And as I mentioned, talking about Commissioner Leipold, we take seriously the presumption, the requirements of proving violations by clear and convincing evidence, and the reputation of those accused. And we have to balance those issues. So I think Commissioner Caruso appropriately pointed out the structural issues, budget, vacancies, and we're doing a good job working on them. I think your comments are very helpful. I don't want to discourage them at all. I think we agree with the principle and we will take your comments to heart. But I think the situations generally are more complex. And I can tell you, speaking for my colleagues, that we have observed great diligence on behalf of the staff of the commission in trying to make sure that justice is not delayed.
I appreciate that. If I could just say two things, and not to be argumentative. One is I did make an ethics complaint a number of years ago, and my recollection is it was dealt with much more rapidly than it is today. And secondly, I know there are resource issues, and with all due respect, it's your job to fix those, and working with the legislature or whoever you need to, and to work. I really believe that if you have a hiring and, from my own experience in business, if you have a hiring and retention issue, you need to figure out what's going on and direct it head on and not just do whatever you've been doing in the past because it doesn't seem to be working. So with all due respect, I've raised this issue. I think you've got significant delays. I don't think any of you like it. I think you need to spend some time figuring out how to fix it.
Any other public comment? Hearing none, I'll entertain a motion to adjourn.
So moved.
I'll second.
All in favor?
Aye.
Aye. Thank you. We are adjourned.